My Lords, I had just got to the other asserted contributions, and then I will have finished 1B. So the company skeleton and the AAHG skeleton focus on the rights of the Class A creditors that they gave up to launch the plan, as opposed to rights they're compromising under the plan. And they appear to rely upon these two rights. First of all is the waivers to release 400 million of cash from the WBS structure, and secondly is the waivers of the events of default in relation to the plan. Mm-hmm. In our submission, a focus on those rights fails to engage with the correct question in relation to horizontal fairness, and I'll just make a couple of submissions. First of all, the 400 million is not new money. That is the group's money, which was subject to restrictions. Second, the waivers that are relied upon are not a direct contribution to the purpose of the plans, for the benefits it generates for the company and the group. They voluntarily waived those rights in order to achieve the ability to enter into the plan. The STID waivers are not contingent on the plan, but rather the continued application of the TSA, the Transaction Support Agreement, and these rights are not the rights that form part of the compromise or arrangement that is the focus of the plan. And the final point we would make is that if we were then looking at the comparative rights, these rights do not justify the rights which the A's get. That brings me to ground 1C, which is the out of the money ground. The only justification left of advanced by the company is that the Class B creditors are out of the money, and it is for the in the money creditors, in other words the Class A creditors, to decide how to divide up the benefits of the restructuring. We appeal the judge's conclusion in both law and fact. As your lordships have already identified, the judge applied Virgin Active in support of his conclusion that the plan was not unfair because the Class B creditors were out of the money, and your lordships see that reliance for your notes on 246, 248, 250 and 255. In section F1 of our skeleton, we make three overarching submissions on Virgin Active. First, the judge misinterpreted what it held. Second, if he did not, the judge erred in following Virgin Active, either because it is wrong in principle or application. And third, if the preceding submissions are not accepted, the judge erred in applying Virgin Active to a SAR. I will develop the third of those submissions. The first two your lordships have in writing, but you are also going to hear from my learned friends, Mr. Thornton and Miss Peters.
2 is not open to you in this court, is it?
Pardon, my lord?
2 is not open to you in this court. It's not open to say to us
my lord,
that the decision of this court is wrong in principle. You can say that to the Supreme Court.
My lord, I will leave it to others to develop the submissions. Your lordship said it may well be that they were obiter. If I was developing the submissions, that is certainly one that I would make. But I'm sure that they've heard what you need.
A bit of convincing by whoever it is who makes the submissions. Fair warning now.
Well, my lord,
it was obiter.
Well, my lord, I'll blow the whistle and I'll watch my learned friends go over the top.
Yeah.
So, my lords, if I can just brief
dugout, Mr. Philip.
Pardon, my lord?
You'll hide in the dugout.
Something like that, my lord. So, my lord, may I just deal with the third of our three submissions, which is it does not apply in a SAR, because in my submission this is important and it was lost sight of. Yeah. The third submission is that even if the judge didn't misinterpret Virgin and accepting those points, the approach is not relevant. It is not does not apply where the relevant alternative is a SAR, and one must remember that we are talking about a special administration regime for a water company. We are not talking about a normal administration. And the underlying premise in our submission of the approach that one sees through Virgin Active is that it is for the in-the-money creditors, who are the economic owners of the business, to decide how to distribute the benefits of the restructuring. However, that doesn't work when it's a SAR, because neither the SAR nor the interim plan are distributive processes. They are each processes towards a solution. Whether that solution is a holistic plan, which, as your lordships know, can happen either outside or within a SAR, or a transfer of the business by a special administrator. As your lordships have seen, the primary objective of a SAR is not to realise assets for distribution to creditors, but it is the continuation of supply to customers. And either the rescue with a plan or the transfer of the business out is in order to achieve the continuation of that supply to customers. In those circumstances, creditors' economic interests in the water company cannot carry as much weight. I'm not saying they carry no weight. They cannot carry as much weight as they would when the relevant alternative is a distributive process. If one's looking at a distributive administration or one's looking at a liquidation, one values the company and one says, where does the value break? Who in that process is going to get a distribution? In the context of a SAR, where the alternative is a SAR and you're dealing with an interim plan, being in the money cannot be the only consideration. And that is the point that we make under 1C. And just to strip it back to the usual concept, one has got all those cases that say an insolvency process is a process by which there is a statutory trust in favour of the creditors. You can't say that of a special administration. It's not, they're not held on trust for the creditors. The assets are not held on trust for the creditors alone. They would be held, managed by the special administrator to achieve one of those purposes. So that's the point in 1C in relation to a SAR, which your lordships will be pleased to know leads me to the heading conclusion. If I can bring it all together, the correct questions that the judge failed to ask were: 1, which Class B creditors' rights were varied under the plan and contributed to the benefits derived from the plan? 2nd, what rights do the Class A and the Class B creditors get under the plan compared to what they would get in a SAR? And 3rd, are there any sound justifications for the difference in rights given under the plan? If the learned judge had asked these questions and not misdirected himself in respect of the restructuring surplus, or accepted that the out-of-the-money mantra was a complete answer, he would have concluded that the plan was not fair. He would not have sanctioned it on its terms and either refused to sanction the plan, or, as he did in respect of paragraph 59 of the CTA, suggested that the company amend the terms to ensure that there is equal treatment if they wanted the plan to be sanctioned. So, my lords, that in opening is my contribution. If I may hand over to Mr. Singler, who is going to address your lordships on valuation.
Thank you very much. Yes, Mr. Singler.
My lords, as you will have seen from our skeleton argument, we submit that the judge made a number of fundamental errors in his assessment of the valuation evidence. That assessment is contained in a short section of the judgment at paragraphs 175 to 196. And we say that, in a nutshell, the judge was wrong to find that the company had established that the Class B creditors have no genuine economic interest or are out of the money, either on a going concern basis, which, as you've heard from Mr. Phillips, we contend is the correct legal approach, or in the relevant alternative, which is the learned judge's approach. And accordingly, we submit that given that the judge's exercise of discretion at the fairness stage of the analysis depended on the out-of-the-money finding, we submit this court should approach the exercise of discretion afresh on the footing that the Class B creditors have not, in fact, been shown to be out of the money. Now, I intend to divide my submissions as follows. First, I'm going to say something very brief about the approach which we submit this court should take to the valuation findings in the particular circumstances of this case. Second, I will explain some points about the regulatory framework. And the reason I need to do that is because one can only properly understand the valuation evidence with a proper understanding of the underlying regulatory framework. And as I'll come on to show you, there are in fact at least two examples on the face of the judgment which show, we submit, that the judge failed to grasp some of the key concepts as regards the regulations. Thirdly, I will summarise the expert evidence, both explaining what was common ground in terms of methodology and approach and what were the principal differences. And then finally, I'll take you through each of the errors in the judgment that we've identified. And we do submit that the judge erred on each of the three main points that were in dispute between the experts. So that's an issue about total expenditure, an issue about the WACC, and an issue about the RCV multiple. And we also finally submit that he erred when taking a step back, as he put it. He said that it was important to take a step back and cross-check the valuation evidence against the trading price of the company's debt. And we say, in fact, that was a plainly false exercise because the trading prices of the debt do not reflect an assessment of the value of the company. So turning first to the approach which we say the court should take to the valuation findings, we obviously recognise, I just should say this at the outset, we obviously recognise and accept what the case law says generally about the willingness of this court to interfere with findings of fact made by first instance judges. But as I will come on to explain, we do submit this is an exceptional case because we submit it's clear that the judge has failed properly to understand the expert evidence. He's failed to take into account relevant evidence. And indeed, as I'll show you, a number of important points in relation to valuation are simply not addressed at all in the judgment. We also say that at least in one place, he refers to what the purpose of the valuation expert evidence was, and we say he was wrong about that. So we do submit it's an exceptional case where this court should be more willing to interfere than perhaps normally might be the case. And I just want to show you at the outset one authority, the Symetra Global Assets and Icon Finance case, which is in the supplemental authorities bundle, the slim blue folder. Now, obviously, this was a different sort of case, but it is helpful in dealing with the general approach. This was an appeal from a judgment of Mr. Justice Knowles, and this court ultimately held that there should be a retrial because essentially he had failed properly to grapple with all of the evidence and all of the issues in the case. And I'd just like to show you three passages. One sees at paragraph 37 onwards the general discussion by reference to the cases with which we're all familiar, the approach of an appellate court to the judge's findings of fact. That's paragraph 37 onwards. But then if I could ask you to look at paragraph 46. This is a helpful summary on which we rely, where 4 points are made, and it's really the second, third, and fourth. It's not necessary, the second point is it's not necessary to deal expressly with every point, but a judge must say enough to show that care has been taken and that the evidence as a whole has been properly considered. Which points need to be dealt with and which can be omitted itself requires an exercise of judgment. Third, the best way to demonstrate the exercise of the necessary care is to make use of the building blocks of the reasoned judicial process. And goes on to saying, giving reasons why the principally relevant evidence is either accepted or rejected as unreliable. Fourth, and in particular, fairness requires that a judge should deal with apparently compelling evidence where it exists, which is contrary to the conclusion which he proposes to reach.
This was an extreme case, whereas paragraphs 5 and 6 make clear the judge produced a 13-page judgment after a 13-day trial.
Yes.
In this case, the judge produced a judgment which I think from recollection is about 180 pages in a week after the trial. And the issue is not really did he deal with every single point. Is there some point that he failed to deal with that is actually critical to the resolution of the case?
Yes.
I don't think Symetra is going to help you in the slightest on that.
No, my lord, the reason I point to that case is obviously it was exceptional, but in relation to the valuation section of the judge's judgment in this case, it is, as I say, a very compressed part of the judgment. Of course, it's a very substantial judgment when looked at as a whole, but the valuation evidence was very complex and is dealt with in summary terms in the judgment. And all I'm really pointing to, Symetra, is for the proposition that effectively there is a risk, as the court goes on to say in 47, that if these requirements are not followed, the reasoning of the judgment will need to be particularly cogent. Otherwise, there'll be a risk that an appellate court will conclude that the judge has plainly failed to take the evidence into account. And the submission we make is, as I'll come on to explain, is that there are some key points which are not dealt with at all in the judgment, and indeed that's common ground. Of course, the company says, well, these were just minor slips, or the judge didn't need to deal with every single point expressly. But the principle here is that, in fact, fairness requires that the key points are dealt with. Otherwise, the appellate court will conclude the judge has plainly failed to take the evidence into account, and that's the submission that we will be coming on to make. And also, I'd just like to show you paragraph 134, which is again directly relevant, not because of the facts of this case, but I think Lord Justice Mayles at 134 and 135 says, in effect, the judge took a shortcut and lost sight of the evidence as a whole. And then 135, there's nothing wrong with a shortcut, provided you don't get lost. And one of the points I'll come on to make is that in relation to the RCV multiple, the judge expressly says he's taking a shortcut because he hasn't had time properly to consider the evidence. And we say, well, there's nothing wrong with that, provided you don't get lost. And he did get lost. And finally, on Symetra, at paragraphs 169 to 173, the court observes that the judge in that case misunderstood the purpose of the expert evidence. And again, as I'll come on to explain, in our case, where the judge referred to what he regarded as the purpose of the expert evidence, we submit he actually got that wrong. So there are some analogies to the Symetra case. This we do submit is an exceptional case. But my lord, if I can be clear about this point at the outset, we do accept that the judge was in an extremely difficult position in this case. And as you know, we submit that that was the result of the company's decision to commence these proceedings late and to contend that the Class Bs were out of the money. So the judge was left in a very difficult position, having to deal with a complex valuation dispute with very limited time. He was given a matter of days in which to produce the judgment. And we therefore say the judge was placed in a difficult position, but this court should be more willing to interfere in this case than in perhaps a usual case where the trial judge has had the benefit of hearing days and days of expert evidence and having a proper opportunity after the hearing to reflect upon that. We say, in fact, the judge was placed in a very difficult position. He could have, we also make this point in our skeleton, he could have simply said that the company had put the court in such a difficult position that given the evidential difficulties, which I'll come on to show you, he expressly refers in his judgment to the fact that there are evidential uncertainties and to the fact that he's had insufficient time. And we submit he could have decided to say that the company had not discharged the burden of proving that the Bs were out of the money. But in fact, he went on to make a finding on the balance of probabilities. And we say once he decided to make such a finding, then it's open to this court to review that finding and to consider whether, in fact, as we submit, he made some serious errors in that assessment. And as Mr. Phillips said earlier, if in fact the test is all there needs to be is a real, as opposed to fanciful or theoretical economic interest, then all of the criticisms which I'm about to come on to apply a fortiori. But before turning to the judgment, can I quickly show you some points about the regulatory framework, which it's convenient to see in one of the expert reports. These points at this stage are not intended to be controversial. They're simply statements as to how the regulatory framework operates. And it's convenient to pick these points up in Dr. Grunwald's report, which is in the supplemental bundle, tab 15. I don't know to what extent the courts have an opportunity to read the expert reports, but if I could just perhaps show you some passages just to tee up the points on the valuation evidence.
What page is it?
It's tab 15 of the supplemental bundle, page 521. Section 2 is concerned with the regulatory framework, and paragraphs 2.2 to 2.5, Dr. Grunwald explains that the way the framework operates, 2.2, the prices are set by the regulator rather than by normal market forces, and at 2.4, the regulatory framework is designed to foster the objective of ensuring that the companies do not abuse their market power, but also provide affordable services, and to ensure that the water companies' financing needs are met. So prices need to be high enough that returns are adequate, but not too high in order to protect the interests of consumers. And then at 2.5, your lordships will have this point. The framework operates on a 5-year cycle. And then 2.6 through to 2.14 are important paragraphs for the purposes of understanding the valuation evidence. So Dr. Grunwald starts by 2.6 onwards, starts by explaining the 5-year process with business plans and then the price reviews and so on. But then at 2.9, this is where one gets into the detail, the operating expenditure and capital expenditure referred to as Totex, which is a concept we'll need to grapple with in due course, and the costs. So the costs incurred by these companies are recovered both in the current period, she says at the end of 2.9, that's the fast money directly recovered via customer bills. 2.10, the costs that are recovered over a longer period are referred to as slow money. And then she refers to each company having a regulatory capital value, RCV, reflecting past investment that is yet to be recovered through customer bills. So current period investment is in effect added to the RCV to then be run off. And then 2.11, every year the RCV is adjusted according to inflation, depreciation and new investment. And then 2.12, the revenue requirement in any given period is, as a result, based on 3 main components. The Totex fast money, broadly calculated as the OPEX element of the Totex. So there's the Totex fast money, the periodic RCV runoff, which is effectively depreciation, and the allowed return on RCV, which is calculated as WACC multiplied by RCV. So that's an important point. Customer prices contain these 3 elements of cost. And over the page, there's a diagram which shows that. One can see under the allowed revenues.
We haven't got there yet.
Oh, I'm sorry.
Yeah.
One can see the figure 2.2, regulatory framework for allowed costs and revenues. And one can see the allowed revenues have those 3 components: Totex fast money, return on RCV, RCV runoff. And you can see that the WACC is used by Ofwat to calculate the return on RCV. And at 2.16, Dr. Grunwald explains the WACC. So in quantifying an allowable return on capital, Ofwat computes a weighted average cost of capital using a notionally geared capital structure. So this is also relevant to one of the criticisms we make about the judgment. So important to understand the way Ofwat uses WACC. And then, if I could ask you to look at 218. She explains, under the regulatory framework, a company's future cash flows are NPV neutral if the present value of future cash flows and the increases in RCV equal the RCV. In other words, a water company that's NPV neutral will have an EV, enterprise value, that is equal to its RCV. In Ofwat's view, NPV neutrality is key to ensuring that investors are fairly compensated. And at 219, she explains that NPV neutrality fails when a company deviates from Ofwat's expectations. And then 223 and 224, Dr. Grunwald explains that there is a mechanism for cost sharing, so that if a company overspends, i.e. spends more than the Ofwat allowed amount, then in fact it's entitled, pursuant to this cost sharing mechanism, to pass on some of that overspend to customers. And at 247, Dr. Grunwald explains, 247, Dr. Grunwald explains that in practice there are in fact differences between a company's RCV and its enterprise value, and she refers to a paper from Auxera. So, although she had referred to NPV neutrality as being the way in which the system works from Ofwat's perspective, what she's explaining here by reference to Auxera is that in fact there will be differences in practice between the RCV and the enterprise value. For example, one can see the bullet points, investors taking a view on cash flows and so on, and investors' assessments of their required return. And this is all important to one of the errors in the judgment. And then, if I could show you 323, so that's page 542 of the bundle. This is just to show you something called the aggregate sharing mechanism, which is another cost sharing mechanism. So that, in fact, the way the system operates is that if a company overspends, there are two cost sharing mechanisms. The first one that I showed you at 223 and 224. And then if the overspend is to such a degree, one is in the territory of the aggregate sharing mechanism. And that's going to be important for one of my submissions later. And then finally, if I could just show you 374 on page 556. This is just to show you the section on RCV multiples, where Dr. Grunwald says that standard valuation practice to assess the terminal value of the company at the end of the discrete projection period, and she explains in the final sentence the terminal value that both she and Mr. Wirrising have assessed is at 2040. And finally, 389. On the, oh, I'm sorry.
It seems to have gone on to a different.
That's page 562.
389, yeah.
And this is back on the question of the relationship between enterprise values and RCV. These precedent transactions, as they were referred to in the evidence, one can see that in previous transactions, the implied enterprise value RCV multiple is always in excess of 1. And that's going to be important to a point I'll come on to. And this, to be clear, those precedent transactions appeared in Mr. Wirrising's evidence originally, and in fact he also explained some of these implied enterprise value RCV multiples, but they're all in excess of 1, which is the key point. Now,
This is the difference, is it, between Mr. Wearsing's 1 and her 1.2? Is that the point?
that's the relevance of the point, yes. Yeah.
And
So
that's
I'll
why
come-
she says in 390 is unrealistic, suggests as he does, often extend the period of recovery to industry standard performance. Thames Water not related to command an industry standard premium to its RC.
Exactly.
So her view is it's 1.18, which is then rounded up to 1.2. His view is it was 1,
Yeah.
1x. And the judge preferred his evidence to hers,
Yes, and I'll come on to that particular aspect of the judgment, but I just wanted to set,
having seen the witnesses giving their evidence,
well, my lord,
formed a view as to their relative credibility, etc., etc.
well, my lord, with respect, when I come on to that part of my submissions, one sees, in fact, the judge made an error in terms of the starting point of the analysis on the multiple.
Okay.
Just perhaps to mention now what that particular error was. What he missed on the multiple point was that both experts had actually assumed that there would be a decade of performance in line with Ofwat, so 2030 through to 2040. And what the judge does, and I will come back to this obviously, but just to perhaps foreshadow the point, the judge wrongly says in the judgment that Dr. Grunwald and her 1.2 assumed significant outperformance, and that was just completely wrong. So my lord, I just want to explain the background. I mean, all of that actually is broadly common ground. I'm not sure any of those points that I've shown you are controversial. Of course, the interpretation of those multiples is up for debate, but the basic facts are common ground. Now, I want to, having explained the key points in terms of the regulatory framework, I just want to show you why we say the judge appears to have misunderstood aspects of the regulations. And if one can look at the judgment at 177, that's paragraph 177. Your lordships will see that there were 3 principal differences between the experts, and I'll come on to each of the differences in a moment. But
Core bundle 1, page 170.
I'm grateful, yes, 170. Page 170.
Page 170 of the core bundle.
So at this stage, I'm not addressing you on the substantive errors. I'm just dealing with his understanding of the regulatory framework. And if one looks at 177, where he says, secondly, in calculating the WACC, Mr. Wearsing based his valuations on a variable discount rate, which he derived by reference to market yields. By contrast, Dr. Grunwald adopted the same rate as Ofwat had used in producing its RCV. Your lordship see that's the crucial sentence for this purpose, because in our respectful submission, that sentence demonstrates a fundamental misunderstanding of the regulatory framework, because Ofwat does not, in fact, use a WACC to produce the RCV. The two concepts are entirely distinct. The regulatory WACC is calculated to provide a reasonable return to the investors, whereas the RCV is the value of the past capital investment that is yet to be recovered through customer bills. And the company, to be clear, although there's whispering to my side, the company accepts in their skeleton that that is an error. They characterise
They
it.
say it doesn't make any difference to the judge's conclusion.
Well, my lord, of course they say that, but with respect, the building blocks of the valuation evidence in this case is a proper understanding of the regulatory framework. One can't actually understand the expert evidence in this case without having a proper handle on the regulatory framework. And that's one example where the judge has conflated the concepts of WACC and RCV. They're completely distinct. And if one
We've got
look,
the wrong thing on the screen, page 170, not page 177. 170 and 171.
and that's one example, my lord. And then the next is if one looks at paragraphs 183 to 185.
That's pages 172 and 173.
Yes, I'm grateful. You'll see this is a section concerning WACC, and I'll come back to the substance of the WACC reasoning. but you'll see at 184, where he says he prefers the evidence of Mr. Wirasing, he says, I accept Dr. Grunwald's evidence that market expectations are different from and even inconsistent with the assumptions used by Ofwat to calculate the RCV. And again, that's just, with respect, wrong. He's not properly understood the distinction here between WACC and RCV. They're fundamentally different concepts. And we do submit that this confusion would inevitably have infected the judge's ability to understand the valuation evidence. Because, to be clear, that these concepts of WACC and RCV are fundamental to the principal issues that were in dispute between the experts. Now, turning to the valuation evidence in this case, there was a great degree of overlap in the approach and methodology of the two experts. And your lordships will have picked up that both experts sought to calculate the enterprise value on a cash-free, debt-free basis, producing a discount cash flow valuations. So they discounted the cash flows over a period of 15 years using a discount rate, a WACC, to derive a net present value for those cash flows. And then they added a terminal value, which was assessed at 2040. So what the experts did, both of them, is that they assessed what the RCV would be as at 2040, taking into account expected capital investment, and then they applied the multiple. Now, the three key differences that the judge deals with in the judgment were as follows. First, what would the actual level of Totex be in AMP 8? And the reason that that was relevant is because an overspend, if the company were to spend more by way of Totex as against the relevant FD allowance, then it wouldn't be able to recover all of that overspend by raising customer prices, and that would depress valuation. So the first issue is what is going to be the actual level of Totex relative to the FD allowed figure. The second point was WACC, and there are two particular issues within the WACC debate between the experts. There was a point about inflation, and there was also a point about cost of debt. So I'll come on to explain those points. And then finally, as my Lord the Chancellor has already pointed out, the third issue was about the multiple, whether it was 1 times or 1.2. The expert findings on, or expert opinions on valuation are set out. There's a table at paragraph 175 of the judgment on page 169.
Paragraph 175.
Paragraph 175.
Yeah.
And one can see the mid scenario of Mr. Wirasing is the figure of 14.7 billion, which is the figure that is accepted ultimately by the judge at paragraph 194. So if your lordship see Mr. Wirasing, and if you look at the mid case, and if you look at the present day valuation, the left-hand column, or the second column, 14.729.
Yeah.
That's the enterprise value, which ultimately the judge finds on the balance of probabilities is correct at 194. And in contrast, just so that you can see over the page, Dr. Grunwald, present day valuation mid-case, was 21.4. They're not quite apples for apples figures, but that's her mid-case present day valuation. And it might be useful before I come on to develop the submissions about the errors in the judgment to explain that in order for the Class Bs to be in the money, as it were, if one's looking at this on a going concern basis, Mr. Phillips has addressed you on the legal aspects, but if one is approaching this from the perspective of a going concern basis, then what one needs to do is look at the 14.7 figure that the judge accepts, and any figure in excess of 17.5 billion would put the Bs in the money. And that means effectively, what I'm not trying to persuade your lordships in this appeal, I'm not suggesting that your lordships say that Dr. Grunwald's valuations were correct, but what we are submitting is that the judge made various errors, which I'll come on to explain, but having accepted the 14.7, using Mr. Wierusing's own valuation, if the judge had taken into account the points which we say he failed to take into account, that would put the bees in the money. That's I hope a helpful point to frame the arguments at the outset. And if the relevant question is not genuine economic interest on a going concern basis, but if one's looking, as the judge did, at the position in a SAR, then the analysis is more complicated. And I can, if time permits at the end, I can perhaps show you, work through the numbers. But perhaps at this stage, I can simply say that if one takes the 16.7 figure, so the relevant alternative means not looking at the present day valuation. The debate was either September 2025 or July 26. And just to give you an indication of what it is we need to persuade you of, as it were, to be in the money, if the question is relevant alternative, one needs to take the 16.7 billion figure using Mr. Wierusing's own number, and then add various costs, which they were referred to below as the SAR overlay. And I don't want to take up too much time giving you chapter and verse on these numbers at this stage, but what we have done is, if one takes Mr. Wierusing's own number, and if one adds the SAR expenses, which the company...
So what are they called, sorry?
Sorry, my lord?
Star expenses?
SAR, the expenses that would be incurred if the company went into a SAR.
Oh, I'm sorry, yes.
Administration, yes. That was described below, my lord, as the SAR overlay that one needed to... So one can't just take the 16.7 million, one has to add what was said to be the costs of a SAR.
Yeah.
And using the company's own figure in that respect, I think it was 288 million.
Yeah.
Which then takes you to a gap of about 4.47 billion. And as I say, I don't want to take up too much time at this point showing you the workings, but we can do that, and we can hand up a document.
A gap between what and what?
Between 16.7, if you add the SAR expenses, you then have a gap between
17.04, and then you say there's a gap of
it would need to be
4.6 between that and
20.89 billion is the number.
Magic number.
So exactly. So the magic the magic numbers on these two scenarios. If it's going concern, the magic number is 17.5 billion.
Yeah.
Which means a gap of
4.6.
No, that's the 2.8. So if present day valuation. So going concern basis, one takes the 14.7 figure, and the magic number one needs to get to for the bees to be in the money is about 17.5. So that's a gap of 2.8. And if one's taking the SAR position, which is the 16.7, with some SAR expenses added, one has to get that number up to the magic number of 20.89 billion, which is a gap of about 4.4.
Yeah.
Can I just ask, why is the 30th September figure, the SAR figure? I thought 31st July 2026 was...
Well, there was a debate below, my lord. There was argument about this below, and where the judge ended up was he didn't accept, I think the company's position was that the SAR exit would be July 2026, and we said September 2025. But at paragraph 293, the judge says he thinks July 26 is too late. So I'm trying to keep this as simple as possible and as uncontroversial as possible at this stage. But I just wanted to explain those points now, so that when I come on to explain each of the errors in the judgment and each of the points that the judge fails to deal with, one can see actually that they do put the bees into the money. Now, I'm going to develop the submissions on the errors in the judgment, dealing first with the Totex issue. As your lordships will have seen, there is a chronology to the Totex issue in terms of the company submitting its business plan to the regulator back in April 2024. and that proposed a Totex allowance of approximately 22 billion. In July 24, Ofwat released the draft determination, giving an allowance of 16.9 billion, so much less than the company had asked for. And then in August, the company submits its draft determination response, which requested a higher Totex allowance of 24.5 billion.
Yeah.
And then ultimately, on the 19th of December, the final determination sets the allowance at 20.5 billion. And crucially, what matters here is not the absolute levels that I've just referred to, but it's the degree of overspend, because that's the issue which drives valuation. And between the experts, there was an issue as to what was the appropriate figure to use in terms of what was the company going to actually spend, as opposed to the allowance. Now, Mr. Wearising used the 24.5 billion figure that was in the draft determination response. And that meant an overspend of 4 billion. So his valuation was arrived at or calculated on the premise that there would be a 4 billion overspend. And that one can understand intuitively that if you proceed on the basis that the company will overspend by 4 billion, that will depress valuation. And one can actually see what the impact of that was in valuation terms. It's 1.9 billion, and one can see that Dr. Grunwald has explained that. But the effect of assuming a 4 billion overspend is a 1.9 billion impact on valuation. Now, the judge deals with this. If one looks at paragraphs 178 to 182, and if you start at 180, Mr. Wearising adopted the Totex figure from the DDR. So he's taken the figure that the company was putting forward by way of its response to the draft determination as the actual Totex spend. And at 181, this is the crucial paragraph, he says the DDR provided the most reliable figure for Totex. Dr. Grunwald gave evidence that the company was likely
Which paragraph are we in?
181, my lord, on page 172. He says that, in my judgment, the DDR provided the most reliable figure for Totex. And then he goes on to say, Dr. Grunwald gave evidence that the company was likely to have inflated the DDR figure in order to bid Ofwat up in reaching its final figure. And I accept there is some sense in this. But in the absence of a very detailed breakdown of the FD and DDR figures, I accept Mr. Cochrane's evidence, and I find that the DDR figure provides the most reliable guide to the group's actual Totex. Now, just to explain...
That's the judge identifying what the difference between the two experts was and what Dr. Grunwald was saying, and accepting that there was some force in the point that they might have inflated the figures, but saying, notwithstanding that, I accept the evidence of the witness of fact, Mr. Cochrane. That's paragraph 180, that the DDR figure, 24.5 billion, which he's accepted as well, the difference is the one between the 20.5 and the 24.5, which they couldn't, a gap which they couldn't bridge. In other words, Cochrane's evidence was this is a genuine gap which we can't bridge. Not that we were deliberately inflating this so we get more out of Ofwat.
But my lord, the difficulty, in our respectful submission, the difficulty with this paragraph is that the judge has actually accepted Dr. Grunwald's evidence that this number was likely to have been inflated. That's the problem, because the judge having accepted...
I'm not sure he is, with respect. I mean, so different judges express themselves in different ways. He's saying that effectively, conceptually, this is what is being said, and I accept that conceptually they might have inflated the figures, but I actually accept Mr. Cochrane's evidence, which was to the effect that they hadn't inflated the figures, because this is what they actually needed, and that was the judge was perfectly entitled to reach that conclusion. He may have expressed himself in a slightly, in a way in which he wouldn't have expressed himself if he'd had 2 months to write his judgment. But the bottom line is that he accepted the witness of fact evidence, which he was entitled to do.
Well, with respect, he accepts Mr. Cochrane's evidence, having said, A, that the DDR figures are likely to have been inflated, but then he says, in the absence of a very detailed breakdown of the FD and DDR figures, I accept Mr. Cochrane's evidence.
Yeah.
Now what, in my submission, the absence of a very detailed breakdown, so what the judge is saying here is I accept, and in fact I would interpose that it's common sense that the company is essentially in a negotiation with Ofwat, so these numbers are likely to have a cushion or some degree of inflation. He accepts that point, and then he says, but in the absence of a very detailed breakdown, I accept Mr. Cochrane's evidence. Now, the detailed breakdown would be a document that the company ought to provide so that the judge can properly assess where these cushion aspects of the numbers lie.
Well, it might be that the FD breakdown would be one that Ofwat produced, wouldn't it?
Yes,
But
but
if we'd had a 3 month, if we had, you know, as is normal in litigation in these courts, 18 months to prepare for a trial, with goodness knows how many case management conferences along the way, somebody might have said, well, can we please have disclosure from Ofwat of exactly how they calculated the FD?
But my lord,
And then we'd have had a breakdown, and then you could see, and the point the judge is making, well, if I'd had the complete breakdown, it might have shown a slightly different picture. But on the basis of the evidence that's before the court, I accept Mr. Cochrane's evidence.
well, we say two things. We say we do say two things. We say one, that there is a problem insofar as he's accepted that there is a degree of inflation, but then defaulted to Mr. Cochrane's. He could have gone
Except
for
there is. He said that he sees the false to point there might be.
the second point we make, my lord, is
Dr. Grunwald doesn't know that there was. It's just he's just expressing an opinion,
yes, which we
which is a perfectly normal common sense that people put in. If you're negotiating, you might very well put in a figure that's higher than one you might get at the end of the day.
exactly, and that's why we say the judge was obviously right to accept
You
that.
might be doing that. You might not.
But what the judge could have done was taken a middle ground. My lord, the point is, this makes a huge difference to valuation. As I said, the 4 billion overspend is a 1.9 billion impact on valuation. And we do submit, just coming back to the more general point, to your lordship saying, well, this wasn't, the judge didn't have, as it were, the luxury of a full-blown trial. That's why we do stress two things. The burden of proof being on the company. So in the absence of a detailed breakdown, we say that lies with the company. We couldn't possibly have produced that breakdown ourselves. And the second point is, going back to the legal test that Mr. Phillips was advancing this morning, it can't be right that in every one of these cases, one needs to have a heavily contested valuation dispute. And that's why we say, in fact, all we needed to show was a real, as opposed to fanciful, economic interest. But my lord, the second...
But you don't even get, on this analysis, you don't even get to an economic interest, do you? Unless you can show that you'd have been partly in the money.
Correct, my lord, but that's why I was trying to explain with the magic numbers, the sum total of the errors that we identify does put us in the money, even with Mr. Wearising's valuation. That's why we've alighted upon these points.
Yeah.
And secondly, in relation to paragraph 181, there was undisputed evidence before the judge that this 4 billion overspend was unprecedented. That's referred to in various places, but including at Dr. Grunwald's first report, paragraph 1.22. It was also undisputed that over the previous 3 AMPs, so that's 15 years, Thames was underfunded by 2.5 billion in total. So this 4 billion overspend, we do say that the judge, with respect, ought not to have essentially taken Mr. Cochrane's evidence at face value. He's failed to mention in this paragraph that it was unprecedented, the disparity, even though it makes a very significant difference to the valuation. And of course, he's failed to refer to the possibility of a CMA appeal. At the time of the sanction hearing, your lordships would have picked this up. The company was saying they hadn't yet decided whether they would appeal or not. They duly did decide to appeal. And again, the undisputed evidence from Dr. Grunwald, I won't take you there because of time, but it's paragraph 3.28 of her report. she explains that in all of the past appeals, the Ofwat allowances have been increased, so the overspends have been reduced, and none of that's referred to by the judge, even though all of those points would have fed in to valuation. And then the final point that we make in relation to Totex is, even if your lordships take the view that the judge was entitled to use the DDR figure, he has completely failed to mention an important point here about the way the regulatory framework operates. So as I explained when I took you quickly through Dr. Grunwald's report, where there is an overspend, the Ofwat regime has two cost-sharing mechanisms. The first one we don't need to concern ourselves with, but because both experts had factored that in. But the second, which is the aggregate sharing mechanism, that's something which the judge has failed to refer to. That aggregate sharing mechanism, I won't go back there, but it's paragraphs 323 and 324 of Dr. Grunwald's first report. That was completely ignored, left out of account by Mr. Wiersing in his first report. And in his second report, Dr. Grunwald having pointed out the error, Mr. Wiersing calculates the impact of the ASM, as it's referred to, the aggregate sharing mechanism. The impact of that on valuation, he says, is 750 million. And that's, for your note, paragraph 4.4.3, subparagraphs E and F. And what he said in that report is he accepts that the value of the ASM is 750 million on valuation, but he refers to it as a potential upside. He seeks to dismiss it, in other words, and say, well, it's not really relevant, it's all a bit uncertain, because this is a new cost-sharing mechanism. During his oral evidence, he in fact admitted that this ASM would likely be triggered in his valuation. That's day 2, page 178. And he accepted also, as he had to, that taking into account the ASM would increase his valuation by 750 million. And as I say, all he could say in response was, well, it's uncertain as to how it might operate. But my lord, what we say is not, one doesn't see any reference to that in the judgment. There's just no reference at all to the aggregate sharing mechanism. There's no reference to Mr. Wiersing himself saying that it was a point worth 750 million. And that, in my submission, was a very material point in the context of the valuation. It would increase all of Mr. Wiersing's figures across his range. They would all go up. Now, the company in their skeleton for this appeal, they accept, as they have to, that none of these paragraphs refer to the ASM. And of course, they resort to the general submission that, well, there's no need for a judge to deal with every matter in the judgment. But we don't accept that with respect. There's a complete failure here to refer to a very important aspect of the regulatory framework, the aggregate cost-sharing mechanism, which ultimately both experts agreed is a feature of the new system. And in circumstances where, again, it was common ground that the ASM had an impact of 750 million, we simply don't accept the submission from the company that the judge didn't have to deal with every single point. We say that is a material point which doesn't feature in the analysis on Totex. Now, the next category is the WACC, the WACC issue. In relation to WACC, we say the judge fell into error in two respects. First, inflation, and second, cost of debt. And these are actually conceptually quite similar points. And the errors here.
I mean, what Mr. Smith says in his skeleton argument at paragraph 64 is slightly more nuanced than you've just put to us. I'm not criticising you, but I'm just saying he makes the point that Mr. Wiersing he explained why he didn't include the ASM in his principal analysis. That's in his original report, because of the uncertainty as to how it might operate, because it was a new concept, as I understand it. But that he had included a sensitivity to reflect its possible effect. Yeah. And it was clear the judge understood that. And Mr. Wearising explained taking the estimated effect of the ASM into account did not move the EV of the company outside his range of concluded values. In other words, didn't move it outside the 16.7 million, as I understand it.
Well, what he said, sorry, my lord, the reason I didn't deal with this more fully was just because of time. But what's being said, so what Mr. Wearising said in his second report was, this point I accept is a feature of the Ofwat system. And in fact, he footnotes the relevant provision of the Ofwat. And he says it's worth 750 million. But then he says, it's all a bit uncertain. And I can take you to the report, my lord. It's supplemental bundle, tab 23, page 900. Does your lordship have paragraph 4.43? So, my lord, so this is a long paragraph. We don't need to go through all of it because ultimately he tries to explain why he failed to take it into account in his first report. Then when you get to subparagraph F, he says he ran the ASM and the resulting impact on the concluded value is 750 million. So that's the figure I've been referring to. And he says, which is within the range of my concluded values and can be considered as a potential upside. Now, just breaking that down, it's not a potential upside, it's a hard increase to the valuation. And on the point that your lordship's put to me about the range of concluded values, what he's saying there is he's got a low, mid, high case, so 750 million is dealt with, as it were, because he's got a low, mid, high case. But what he's failing to grapple with, and of course there's no analysis of this in the judgment either, is that in fact the ASM will impact all of the values in his range.
Well, he goes on to say at G, I would like to highlight the exact implications of the ASM mechanism and certain sensitivity calculations I present above the most optimistic.
Yeah, but that's the most optimistic.
Ratio might have been lower than I assumed. In other words, he's saying, well, 750 is pretty optimistic.
Yeah. He's grudgingly accepting that he has to take this into account. And he says, well, 750...
He's grudgingly accepting it, but that's a bit offensive. But there we are.
No, my lord, he's saying he's both accepting that the ASM is there, but also saying he doesn't have to...
Well, he's explaining why he hasn't... It's effectively explaining why he doesn't really think much of it. He may be right or wrong about that.
Well, my lord, he says it's...
The real issue is whether the judge should have added 750 million to his, whatever his figure was, 16.7, to get you to a point where you can say, oh, we're in the money now. So all the rest of it unravels, which is what this is all about, isn't it?
Exactly, my lord. And actually, it's not just this point, it's also the sum total of the other points.
I follow that.
We do respectfully submit that at the very least the judge ought to have dealt with it, and one can't be confident the judge being silent on it, that the judge has properly understood the 750 million and the impact that that has on the valuation. Now, I was going on to the WACC issue, and in relation to WACC, can I just deal first with the inflation point? Now, the inflation point is can be explained quite simply in the following way. Ofwat, when doing its modelling, uses an inflation figure of 2%, which is the Bank of England target for inflation. It uses that figure when modelling WACC and across all other aspects of its modelling. So Ofwat obviously doesn't need to discount cash flows and so on and arrive at an enterprise valuation, but it does have a WACC figure in order to calculate the allowed return. And it's on common ground that Ofwat uses 2%. And it's also common ground that Ofwat, that the way the system operates is that there's an inflation adjustment mechanism, so that if inflation turns out at the end of every year to have been higher than 2%, then Ofwat will essentially increase the revenues and the RCV of the company at the end of the year. so that effectively if the revenues, the allowances and the RCV are increased, then the companies are entitled to increase prices. In other words, companies are inflation proof. And that was common ground. Just for your Lordship's note, it's page 36 of Mr. Wearising's first report, supplemental bundle page 216, and it's paragraph 347 of Dr. Grunwald's first report, so page 548. I might just show you what Mr. Wearising said about this, actually. If I could ask you to look at his first report, page 36.
Sorry, page?
Internal page referencing 36. It's 216 of the bundle.
216 of the bundle.
Behind tab 6. It's supplemental bundle, tab 6, page 216.
For some reason it's sideways.
And my lord, it's on the screen. I'm grateful, but this is just to show you that Mr. Wearising himself is referring to the fact that there is a mechanism by which Ofwat indexes by general inflation, and you'll see the second paragraph. We understand that revenues are indexed by general inflation, revenues and RCV, because Ofwat believes these risks should be allocated to companies where they have control over those risks. Since companies cannot control general inflation, they are protected from this risk. And then he goes on to say, underneath the bullet points, Ofwat will true up the inflation allowances once actual inflation data is published. So it's common ground that essentially Ofwat, when doing its modelling, uses 2% as a holding assumption as to what inflation is. Mm-hmm. But then at the end of each year, it will actually adjust things so that the company is inflation proof. It will recover actual inflation through prices. And what happened in this case is that both of the experts, when using the company's Crabtree model, which contains the cash flows, the experts used the model which inflates cash flows at 2% as well. But when building their respective WACC figures, the discount rates for the model, Dr. Grunwald tried to stay aligned, broadly aligned. In fact, she used a slightly higher figure, but broadly aligned with Ofwat, using a figure just above 2% for inflation. Mr. Wearising, by contrast, used a figure of 3.3%. And he did that on the basis that that was the market view of inflation, which is obviously higher than the Bank of England target. Now, the simple point here is that although there was a debate about whether or not it was appropriate to use a market rate for inflation when building a WACC, the critical point, the criticism that Dr. Grunwald was making, was not in fact about the use of a higher rate per se. It was that there was an internal inconsistency within Mr. Wearising's model, because what he had done was he had used 3.3% as the inflation figure when building his discount rate, but his model only inflated cash flows at 2%. And that was the key criticism made by Dr. Grunwald in both her written evidence at paragraph 3.58 and also in her oral evidence. And if I can show you 358 of Dr. Grunwald's evidence, it's supplemental bundle page 551.
Which tab is it?
I'm so sorry, my lord. It's tab 15. And what Dr. Grunwald explains here is the need to use consistent inflation assumptions. If one's working on a discount cash flow model, one has to use the same inflation figure, both for the cash flows and in the discount rate, in circumstances where, as was common ground, the regime makes the companies inflation-proof. So that's the criticism, and she explains at 359 the effect of Mr. Weerasing's approach, which was essentially to build a high discount rate with a higher inflation figure, but not to offset that by increasing cash flows. That depressed valuation by 1.7 billion. So that's Mr. Weerasing's own valuation figure is off by 1.7 billion. And in one sense, I should just explain, because Mr. Weerasing updates his figures, Dr. Grunwald then addresses this in her second report, where she says it's between 1.9 billion and 1.6 billion. I won't go to it, but it's figure 2.1 of her second report. So this is a very significant point. Mr. Weerasing's valuation is depressed because he's used internally inconsistent inflation figures. And that's contrary, not only is it contrary to the way the regime works, but it's also contrary to general principles on DCF modelling. And we've included in the bundle an extract from a book by McKinsey on valuation, which makes this very point. Again, because of time, I won't go to it. It's Authorities Bundle, tab 132. And essentially, it just makes the point that to be consistent in a DCF model, you have to use the same inflation figure across cash flows and the discount rate. Now, ultimately, Mr. Weerasing did, in his oral evidence, accept that this is what he had done. There was some confusion, but ultimately, in the transcripts, one can see at day 2, page 176. My lord, I see the time, but could I perhaps
Just finish this.
Yes. Day 2, page 176, at transcripts bundle, page 169, please.
I'm getting confusion now with numbers. We're not on the right page. 169 of the bundle.
Of the transcript bundle, yes, my lord.
Yeah, 169, page 169 of the bundle. Yeah, you're looking at the mini-script pages, so you're confusing. Yeah, okay, right.
Do you see it's 176 of the transcript,
Yes.
and you'll see the question at line 19. Your discount rate uses 3.3% as your inflation assumption. And he says, I don't actively use that, but he's taken it from the inflation rate embedded within the index guilds. So it's 3.3% in his discount rate. And then over the page, Mr. Phillips asks, your cash flows use 2.2%. Is that right? Line 4 and 5. And he says, yes. So in AMP8. And then they trend down. So, my lord, by the end of the proceedings, it was common ground that that's what he had done.
Yeah.
And what one doesn't see anywhere in the judgment is any analysis of this inconsistency point. And perhaps after the break, I could just show you the relevant paragraph in the judgment.
Well, it's paragraph, the judge quotes Dr. Grunwald, including paragraph 3.58, paragraph 183 of the judgment.
That's exactly right, my lord. But
Some length, and then says he prefers Mr. Weerasing's evidence.
That's exactly right. And just perhaps if I can, on that basis, just make the submission before we break. The submission is, my lord, the judge doesn't deal there actually with the internal inconsistency point within Mr. Weerasing's model. That's the problem with this aspect of the judgment. The judge is focused there on the debate between the experts as to whether it was appropriate for Mr. Weerasing to use the market rate of inflation, which, as I say, was not the core criticism made by Dr. Grunwald. What the judge has just not dealt with anywhere is the point that I've just referred to, which is within Mr. Weerasing's model. If your lordship read this section on WACC, there is nothing about the internal inconsistency.
No, and the judge also makes the overarching point at 185, doesn't he?
Yes, well, I'll come back to one.
World versus the academic world, as it were.
Yes, but we say that's rather, well, 185, my lord, is where he deals with, he first says the purpose for which they gave valuation evidence. I'll come back to that aspect. But the academic comment we say is, with respect, rather unfair in circumstances where, having quoted from Dr. Grunwald's evidence, he hasn't actually dealt, the judge, with the point that she was making, which was the internal inconsistency point. And as I say, this is a point which has an impact of 1.7 billion on Mr. Wirrising's own figures. And that's why I'm taking these points in stages, my lord, because one builds up the cumulative impact of the errors that we identify.
But I mean, the judge did go on. I mean, you're making your points about whether his valuation exercise was flawed. But I mean, he does conclude at 196 by saying, well, although he prefers Mr. Wirrising's evidence to the effect that you were out of the money, he then goes on and says, well, if I'm wrong about that, he then does consider the two aspects of the scheme which your clients complain about.
Oh, my lord, that's a nuanced point about I'm conscious of the need for a break, but what your lordship's put to me is actually very important to understand, that where the valuation evidence fitted in at trial, or at the sanction hearing, and where it fits into this appeal is actually different because things have moved on. And it's quite a complicated point which I might need a few minutes to explain to your lordship.
Well, let's try to find it correctly.
Court rise.
Sorry. What we discussed the other day. On time, those initial comments. I think this is we see the space we have half.
Well, we're going to take
Not in this time.
I'm warning you. In terms of when you guys finish, we will factor in what time you want to leave yourself.
I mean, I'll leave it to you and Mark to negotiate.
So I mean, it's up to you. I mean, you
Yeah, I mean, that's the bit that you see where we go.
yeah. I mean, you can finish. It's up to you.
Tom, I'm not doing it all, so.
I know, but you're
just don't have
collectively
control.
sort of. I mean, yeah. You guys just think about
No, so can you remind me what paragraph he does? 196, okay.
Great.
Yeah, so this is no what's on. We're talking about the context of fairness. So that is not an answer.
You take the 16%.
Yeah, this is why we say this matters, is because one goes to, as you've identified, we say, he says at 250. This is the point that we say this goes to. It goes to 250. And it goes to 255.
Yeah.
It's very sensitive. Yeah.
Well, he has a SAR overlay for 0.84 for September 25.
Yeah, so it's a SAR overlay as well.
It's on 669, I think. In these tables, it's got a SAR overlay.
Yeah.
And then for September 25, it's 0.84.
But hang on, so how does that relate to this 1.3?
Well, 1.3 is for
Yes, and the 504 is included.
Yeah.
You don't get a total. 3481. Yeah. But that's it's not that figure.
Yeah.
What I do, you put times it by page number.
Divided by the page. Oh, sorry. But it's
Yeah.
Yeah, well, when Georgia's back up.
Yeah, I know.
I'll just
Yes, yes, yes.
just wanted to
Yeah, I didn't ask him. But this one, this yeah, this that's actually something else.
Hang in there. I'll tell you what, you actually made it clear that I asked the right question. And you correct the chair.
a random thought from earlier on. Slash. You can have illustrations. Don't pretend it's
Some suggestions? Should have drinks. Nobody has drinks.
Can't say you it's small C and plus. Just Tom's answer.
those in favour?
My Lords, my next topic was cost of debt, but could I perhaps just answer the question on paragraph 196, which, as I say, requires me to just perhaps take a step back and explain how the valuation evidence fitted in at trial. At trial, and all of the paragraphs in the valuation section that we're looking at are in the no worse off part of the judgment. And what was being said at the sanction hearing was both parties had competing valuations, and then those competing valuations fed into the inquiry as to whether the Class Bs would be worse off under the plan or the B plan or a SAR. The position of the company was that we were completely out of the money in a SAR, so there'd be zero recovery, whereas under the plan there'd be 3.5p recovery. That's how they approach the no worse off test, and that's ultimately what the judge finds. What we were saying at the sanction hearing was through Dr. Grunwald's evidence. She was saying there was actually a recovery of 100p in a SAR for the Class Bs and 100p under the plan, subject to the control terms. And that's why there's a reference to the diversion of value caused by the control terms. So that brought the 100p under the plan on Dr. Grunwald's valuation down. And that was the position that the Class Bs were advancing at the sanction hearing. They were worse off, because if you had Dr. Grunwald's valuations plus the diversion of value caused by the control terms, that would leave the Bs to be worse off under the plan. The things have moved on now, because for the purposes of this appeal, we are accepting that the no worse off test is satisfied, and we're just proceeding on the basis of the fairness aspect of the inquiry. And in relation to fairness, paragraphs 250 and 255, the judge took into account his findings that the Class Bs were out of the money. So the way in which our appeal proceeds is not to challenge the no worse off finding, but to challenge the finding that the Bs were out of the money. And as Mr. Phillips submitted this morning, we say, in fact, at this stage of the analysis, the question is out of the money on a going concern basis, alternatively out of the money on the relevant alternative. And what we're doing on the appeal, my lords, is we are actually working with the figure, the valuation figure that the judge has accepted at 194, which is Mr. Weerising's 14.7 billion. So we're not looking to persuade the court that the judge, as it were, ought to have accepted Dr. Grunwald's valuation figures. We are simply saying it's a more modest position, which is to say, if the judge preferred, as he did, Mr. Weerising's valuation, then in fact, if one corrects for all of these errors, that 14.7 billion figure goes up and puts the Bs in the money. And if we're in the money, we say the judge was wrong to approach the discretionary fairness question on the footing that we were out of the money. And so 196, my lord, is in fact referring to the no worse off issue, which is not before this court.
But I don't want to get, so I don't want to get into the sort of linguistic debate about, and also, you know, as to what is the appropriate test and what I meant by no economic design. But what I was trying to be clear about was that is the point of this part of your argument simply to open the door, or alternatively leave the door open, to the judge being required to conduct a horizontal comparison?
Yes.
That's the practical consequence of it.
That's exactly right.
So that, in other words, it provides an answer. The judge, if the right reading of the judgment is that the judge simply said, "You're out of the money, no worse off, I can forget about you. don't have to weigh up whether the points as Fitz has identified make it unfair or not. It's simply irrelevant to a creditor in your position. If that was the net effect of his judgment, then you say that
Exactly.
that he
Exactly.
was wrong because
Exactly. That's
that
exactly.
he should have done. But on the other hand, I mean, but if you're right in the argument that even if you were out of the money, you still have to do it. None of this matters.
Exactly. That's exactly the structure of the argument, my lord. That's exactly right. So what Mr. Phillips was trying to persuade your lordship said this morning was that the judge was wrong to have regard to the in the money, out the money question, and one had to look at fairness considerations in any event. This submission, the argument we're now advancing, is in any event the judge was wrong to find that we were out of the money,
Yeah,
and so even on the judge's approach, he was obliged to take into account fairness considerations. That's exactly how the argument's interrelate.
But doesn't he deal with this in the section under fairness headed the horizontal comparison between 245 and 250?
I'm sorry, my lord.
Between paragraph 245 and 250, the judge deals with the horizontal comparison in dealing with fairness and makes the point at the end of 250. In the relevant alternative, which is the SAR, you were going to be out of the money.
Yes, exactly, my lord, but that's precisely the point that we're challenging. So your lordship's absolutely right. In the section, if one looks at 245, that's the discretion fairness section. And your lordships will see the submission at 246, no obligation to assess because they're out of the money. And 247, the Class B's propositions should investigate the horizontal comparison of fairness even if they're out of the money. And he rejects that proposition at 248. And then one can see, if you go ahead to 250, final sentence, if the junior creditors are out of the money in the relevant alternative, as here, the plan is not unfair and little weight is attached to their views. And at 254 and 255, the very last line of 254, you see a reference to, I have found the Class B creditors are out of the money in the relevant alternative. And 255, given that finding, I'm not satisfied. So the way the judge approached this was essentially we didn't have standing, if I can put it in that way, to advance horizontal fairness arguments at the discretionary stage, because of his prior finding that we were out of the money in the relevant alternative. That prior finding was made in respect of the no worse off test, which we, for the purposes of this appeal, are accepting that the no worse off test is satisfied. But what we say, when one gets to the discretionary stage of the inquiry, we say it is relevant to consider whether we had a genuine economic interest. And we say the judge was wrong to conclude that we had no genuine economic interest, that we were out of the money. We would say he was wrong because even using Mr. Wierising's figures, the errors that the judge made would have added to Mr. Wierising's valuation and therefore put us in the money, and therefore the judge was obliged to consider fairness. My lord, it's very important that I clearly articulate the argument, so if that hasn't perhaps explained
What the
itself.
judge is dealing with at 249 and 250 is the evidence. Mr. Thomas Watson was your witness.
He was.
So your own witness was he was objecting to the plan on the basis that it would be inserting the super senior funding would push down the Class B debt out of the money. That's what he says at 250, first sentence. But and then the judge says, well, in the relevant alternative, which is the SAR, you're always going to be out of the money because the government funding or whatever it is going to always be on top.
But that's what we're challenging, my lord. We don't accept that we're out of the money, either on the going concern bit.
Never out of the money.
Well, my lord, the structure of the judgment is perhaps, it's not very clear because the judge deals with the valuation evidence in the no worse off section of the judgment.
Yeah.
But then his conclusion that the Class Bs are out of the money in the relevant alternative then carries through to the discretion section of the judgment. And what he says is, I don't need to consider the Class B's complaints about fairness because I've already found that they are out of the money in the relevant alternative. That's the structure of the judge's reasoning. Mr. Phillips says, I'm sorry, my lord.
But but no, the judge, I mean, some of this is a bit compressed, as one of you said. But 248 and 249, as I, well, 248 and 249, as I read, he's rejecting the argument that there wasn't horizontal fairness. It says so in terms, I'm satisfied the present case gives rise to no issue of horizontal fairness of the kind explored in that case.
Yeah, but my lord, which we're saying the judge was wrong. We're saying the judge was wrong on a number of levels, but it's important to understand how the points interrelate. The judge. I'm sorry, my lord. Are you about to ask a question? I don't want to speak over you.
No, I'm still slightly puzzled, but I doubt this will have to reread overnight what you've just said. But
yeah.
I mean, you say you were accepting that you were no worse off.
No, we're accepting now, my lord. That was very, very much a live issue before the judge. That's why I said.
I know,
Yes.
I know it's what you're doing now, but your position now is that you accept you were no worse off than in the relevant alternative.
Yes.
Now, I mean, why isn't that also accepting that you were out of the money?
Because, my lord, you can be in the money in both scenarios. So it's no worse off. So the company's position, as I said, if one winds back to the way all of this is being presented before the judge, the company's position was.
Well, that's what I want to
Yes.
be clear. You're saying
You can be in the money,
no worse off, but on the basis that you were actually
Correct.
yes.
Our own evidence, Dr. Grunwald's evidence, was that the bees would recover 100p in both scenarios, and therefore, as it were, the no worse off test wasn't.
You would have got something in both.
Exactly, but then the argument below before the judge was that Dr. Grunwald's evidence was then subject to the SAR overlay, or the diversion of, sorry, not the SAR overlay, the diversion of value caused by the control terms, which was the evidence of Mr. Heiss. So what was being said by the Class Bs before the judge is we are worse off in the relevant alternative because one has Dr. Grunwald's evidence which suggests that we're in the money in both, but the control terms depress the value under the plan, and that's why we're worse off. So I think what your lordship is perhaps asking is if we are accepting that we're no worse off, have we, as it were, sold the pass on in the money or out the money? To which the answer is no, because one can be in the money in both scenarios, but the no worse off test is a relative comparison.
Yeah, so the jurisdictional condition is satisfied, but you say it has different consequences when you come to.
You say, as did Mr. Phillips, this is all about fairness. That's your case, isn't it? This is all about fairness.
Correct.
And that you say the judge has failed to deal with the fairness issue.
Well, but for a number of different reasons. First, we say the judge said, I don't have to have regard to fairness because you're out of the money. And as a matter of law, Mr. Phillips.
You say he didn't deal with it in the appropriate way.
Correct. Because we say to the extent he proceeded on the basis we were out of the money and therefore he didn't have to consider fairness, he was wrong. Because even using Mr. Wearising's numbers with these errors, we were in the money.
Yeah, okay. Well, I think we're slightly going around in circles now, so.
Yes, I apologise.
It's not your fault.
I was just trying to answer the question, but
Move on.
yes. So continuing with the analysis of the errors in the judgment, within the WACC topic, I've dealt with inflation, the simple point being inconsistent assumptions leads to a 1.7 billion depression of valuation. None of that's mentioned in the judgment. The next point is conceptually quite similar. It relates to cost of debt, which is an input into the WACC figures used by the experts. Mm-hmm. And essentially, this is quite a short point, because what Mr. Wearising did was he used a particular cost of debt figure in his first report, and then in his second report, he updates that figure because between his first and second report, there'd been a movement in the market, and so he increased his cost of debt and therefore increased his WACC, and one can see that in his second report, figure 3.1. But again, that's not controversial. That's what he did. And our point here, made by Dr. Grunwald, is there's nothing wrong, inherently wrong, with increasing the cost of debt to reflect a movement in the market. But what you have to do is increase the cash flows as well. Because as with the inflation point, where Ofwat always protects the companies from increases in inflation, so in the context of cost of debt, does Ofwat protect companies from rises in cost of debt? And it's something called the true-up. This is a true-up mechanism. And if I could just show you Dr. Grunwald's report on this, paragraph 2.8 of her second report at supplemental bundle 30.
Supplemental bundle.
Tab 30, page 1044. It's not yet on the screen, but if your lordships are in the hard copy, paragraph 2.8.
Yeah.
He says, I note that in his supplemental report, he increased his estimate of the cost of new debt. Previously, his cost of new debt was close to Ofwat's. Now his figure is significantly higher. He has, however, ignored the cost of debt true-up reconciliation mechanism, by which Ofwat compensates water companies for any actual adverse movements in the cost of new debt. And Mr. Weersing, during cross-examination, confirmed that he hadn't taken this true-up mechanism into account. That's day 2, page 159. Shouldn't be controversial. But the important point we make here is that the judge doesn't refer anywhere in his judgment to this mechanism. And that's notwithstanding that Dr. Grunwald, if your lordships turn over the page, you'll see that her analysis, again, using Mr. Weersing's own valuation, you'll see on the mid case, using the 14th of January date, this makes a difference of 636 million. So it's a very substantial point in terms of the overall impact on valuation. And the judge simply doesn't deal with it. So the reason I say it's conceptually similar to the inflation point is that there are these mechanisms within the system which by the end of the proceedings, Mr. Weersing himself accepted. They both have an impact on valuation, rather substantial, 1.7 for inflation, 636 million. And these are impacts on his own numbers. And we say, with respect to the judge, these aren't points that the judge was entitled not to deal with. These are pretty fundamental points to the valuation exercise that he had to grapple with. I accept, of course, he had very limited time and so on. We say that was all the fault of the company. But ultimately, we do say that the judge had to deal with these sorts of points. If he was going to get into valuation, he couldn't omit points which cumulatively amount to 2.3 million in terms of Mr. Weersing's numbers. So that's what I wanted to say about WACC. And then can I turn to the multiple issue, which is the multiple of the RCV to be applied to the terminal value as at 2040. And it was common ground on this point that the difference between a 1 times multiple and a 1.2 times multiple was 5 billion. And again, just if I can perhaps give you references on this, it's Dr. Grunwald's second report at figure 2.3. And it's Mr. Weersing accepted the impact was approximately 4.8 to 5.4 billion at day 2, page 183. Now the judge deals with this at 186 to 193. So it's a very, very substantial difference between the experts. And you'll see at 188 of the judgment, which is core bundle page 174. You'll see at 188, it was wholly unrealistic to expect the court to sift the evidence and rule on these issues, given the limited cross-examination of the witnesses and the week which the parties gave me to write a judgment. I therefore propose to cut through it. Now, in my respectful submission, that's important because, as I said earlier, there was no obligation for the judge to make these binary findings. But if he did want to cut through it, he could have taken 1.1 being the middle point between.
What are you suggesting the judge should have done in the circumstances? Just thrown up his hands and said, terribly sorry, you haven't given me enough time, there hasn't been an appropriate cross-examination of the witnesses, I'm just not prepared to decide these points at all?
Yes, that's our primary position, and our secondary position is he should have, if he was going to cut through it, as Lord Justice Mail said in Symmetra, if you're going to take a shortcut, you can't get lost. As I'm about to show you, unfortunately the judge did get lost on this point, and that's why we say, my lord, if one takes a step back, that's why we say the test actually to be applied here is that the judge only needed to be satisfied that we have a real as opposed to fanciful interest, because otherwise one is going to have this situation in every case where valuation trials are being conducted at great speed, and inevitably judges will fall into error. But in my respectful submission, the judge has made significant errors, which this court should address. And if one looks at paragraph 189, having decided to cut through this, and not cutting through it by taking 1.1, he says at 189 and 190. So 189, he says, Mr. Wearising's multiple of 1 assumes that by 2040, TWL will return to investment grade ratings and will be meeting Ofwat's expectations. This seems to me to be a reasonable assumption. And then he says, on the other hand, Dr. Grunwald's multiple of 1.2 assumes that it will not only have returned to NPV neutrality, but will have significantly outperformed Ofwat's expectations. And with respect to the judge, as I mentioned earlier, that is actually a failure properly to understand an assumption made by both experts. This is not about significantly outperforming Ofwat's expectations. The experts had assumed performance in line with Ofwat's expectations for a 10-year period spanning 2030 to 2040. And you'll see that in Dr. Grunwald's report, paragraphs 134, 325 and 382. And you'll see that at Mr. Wearising's first report, page 52.
The assumption was, sorry, of meeting. Or what was the assumption?
Performance in line with Ofwat's expectations for a decade, my lord. So one's looking at terminal value as at 2040, following a decade of performance in line, but not significant outperformance. That's just completely, with respect to the judge, completely wrong to say that Dr. Grunwald had assumed significant outperformance. And so actually here, we say the judge, having decided to cut through it and take a shortcut, then approaches the analysis from the wrong starting point, because he's misunderstood what was common ground between the experts. And indeed, the company itself continues to misunderstand this, because in their skeleton, they seem to take the view that the way the experts had approached this was that by 2040, there would be performance in line with Ofwat. Whereas in fact, if one looks at the expert reports, those references I've given you, both experts were clearly assuming a decade of performance in line with Ofwat. And so the judge starts this analysis from the wrong place. And he then refers to, if one looks at the passage...
Where does Dr. Grunwald deal with this in her report?
Dr. Grunwald, she deals with this. Your Lordship, it's in various places. If I perhaps take you first to...
Well, where does she explain why she's used 1.2, whereas he
Oh, you mean the whole issue of multiples is dealt with in section 3 at... and it starts at 374, my lord.
Yeah.
And the particular point I was just making, which I respectfully submit the judge has not understood, is reflected in a number of places. But if you look at 382, which is in this section,
Yeah.
she refers there to the assumption that they've both made, and she cross-refers to Mr. Wearising's report. And Mr. Wearising also, in his oral evidence, day 2, page 188, accepted that the assumption was two AMP periods of average performance, as he described it. So, my lord, this is really quite an important point to understand, because one is assessing the value of the company at 2040 after a decade of performance in line with Ofwat. And at page 52 of Mr. Wearising's first report, he refers to the business plan assuming that Ofwat will establish the allowances at a level equal to actual Totex in AMP 9 and AMP 10. That's page 52, supplemental bundle, page 232. And so, my lord, here we do, as I say, the judge started by misunderstanding what the 1.2 multiple implied. What Dr. Grunwald was saying, so if your lordships go back to the judgment, you'll see that the judge extracts what Dr. Grunwald was saying in her section 2, where she was referring to NPV neutrality. So this is paragraph 188 of the judgment. But as I sought to explain at the very outset of my submissions, what Dr. Grunwald actually said, if one reads her report and the passages I took you to earlier, is she says that whilst Ofwat runs this concept of NPV neutrality, in practice, all of the precedent transactions have taken place, the precedent transactions introduced by Mr. Wearising, of course, all of those transactions have taken place at a multiple in excess of 1 times. And so what, with respect to the judge, he has failed to understand this because he's quoted the passage from her report which deals with NPV neutrality, ignoring the evidence at that stage that Dr. Grunwald then went on to explain that there is a divergence between enterprise values and RCVs in practice. Your lordships will recall I took you to the Oxera reference in her report. So the point she was making was supported by Oxera. That's not referred to because the judge has only referred to NPV neutral regulation. And then he's made the error of assuming significant outperformance. So if one actually understands or clears away those errors, the question then becomes, what evidence was there to support the selection of a 1 times multiple as opposed to 1.2? And we say with respect to the judge that there's nothing to support that. There's no precedent transaction, which is as low as 1 times. There's Mr. Wearising's evidence, his own oral evidence when cross-examined on this, accepted that historically all of these transactions were at more than 1 times, and he simply asserted that they were not a reliable guide to the 2040 position, and you can see that is accepted by the judge at the end of paragraph 190. He says, I accept they're not a reliable guide. It's very unclear what the judge has in mind there, but he refers earlier in 190 to the fact that there was a different, Ofwat had a very different approach to their regulation. That's the sentence at the end of 190. So the judge seems to have dismissed all of the data points based on the precedent transactions on the footing that, well, the regulatory position has changed. But there's nothing to support that with respect. It was just assertion by Mr. Wearising. It is true that in one respect, the regulatory framework has changed as regards financing. So it will be, I think the point he was making, Mr. Wearising, was that going forwards, it will be harder to outperform Ofwat's assumptions as regards financing. That's the limited point that he was making. But there's a whole host of points in the other direction. Because the regime is changing in a number of different respects, with Ofwat requiring significant capital investment and also granting significantly more generous allowances. And all of that was covered by Dr. Grunwald. But we do respectfully submit the judge has failed to take account of all of that evidence and simply saying the historic transactions are not a reliable guide. He simply has failed properly to take account of the fact that there is not a single precedent transaction as low as 1 times. And as I said at the outset of this part of my submissions, if he really wanted to cut through it, given all the difficulties that he alluded to at 188, he should have chosen 1.1 times. And if he had done that, that would have put the Class Bs in the money. My lord, the final topic is the question of a cross-check. So your lordships will see at 191, the heading is standing back. And he says, given the technical nature of the exercise, it's also important to stand back. And then he goes on to compare the expert valuations with the evidence from Mr. Wearising about the levels at which the debt was trading. Just before I come back to the substance of the point, one can see at 193, final sentence, he places significant weight on this cross-check. You see that in the last line at 193. And you see in 194, which contains his conclusion, where he accepts on the balance of probabilities 14.7, you'll see he says, given the cross-check in the second line. So just pausing there, this cross-check was clearly, in the judge's mind, very important. And we respectfully submit he was wrong to rely on this. Now, can I just make a couple of points? First, if you go back to 188, 185. So this is a paragraph within the WACC section, but you'll see at 185, he says it's important to bear in mind the purpose for which Mr. Wearising and Dr. Grunwald gave valuation evidence. It's to establish whether the Class B creditors would be worse off under the plan than they would be in a SAR. This involves the court having to assess whether they would obtain more or less for the Class B debt if they went into the market and sold it, either on the assumption that the plan is sanctioned or on the assumption that TWL has gone into a SAR. In my judgment, Mr. Wearising's evidence was directed at that purpose. So that's a general observation about the purpose, as the judge saw it, of the valuation evidence, even though it's in the WACC section. And one can see, if that's what the judge thought was the purpose of the valuation evidence, one can understand why when you get to 191, he then stands back and thinks this cross-check advanced by Mr. Wearising is very important. One can understand that, but the difficulty is that wasn't the purpose of the valuation evidence. And this is why I showed you Symmetra at the outset, because the judge, with respect here, has failed to understand the purpose of the valuation evidence. At 185, it's simply wrong to say it's about assessing whether they would obtain more or less for the debt if they went into the market. It's nothing to do with that, with respect. It's about assessing the enterprise value of the company. And those are materially and fundamentally different exercises. Because as your lordships will appreciate, what happens in the debt market is not necessarily reflective of what investors regard as the underlying value of the company. In one sense, it's a common sense proposition, but one can understand that where the debt was issued some time ago, and in the meantime, interest rates have gone up and the credit rating of the company has declined, that will impact, those changes of circumstances will impact the yield that investors will require. And in particular, if the yield that investors are looking to obtain is higher than the coupon on the debt starts to trade at a substantial discount to its par value. So one, in fact, needs to be very careful about looking at the current value of the debt in the debt market and inferring anything about the enterprise value.
Is there any evidence either way as to the link between the trading price of the debt and the value of the company?
Well, there was, because Mr. Wearising introduced these debt prices and said, oh, look, they align with where I've come out on my DCF.
Well, that's the old proposition that there's an alignment, but was there expert evidence as to what you could get from debt prices in terms of assumptions about the value of the company.
Well, yes, in the sense that Mr. Wearising was positively asserting that one could infer something, and Dr. Grunwald was adamant that they're actually two completely different exercises. And I'll show you that, I'll give you the reference at least in a moment. But we do say, in fact, my lord, I can deal with that now, because it's actually, her answers on this are quoted in the judgment at paragraph 192.
Yes. If the judge sets out first of all, he sets out what Mr. Wearising said in his second report, paragraph 191.
Yes, that's right. So that's a long extract from Mr. Wearising. And you'll see, just if one picks up the final, if you turn over the page and you look just above 192, the final sentence from Mr. Wearising, just above 192, the observed discount of the traded Class A and Class B bonds reflects the ongoing difficulties the company is facing. So he was clear that one could look at the debt prices, and I'll come on to the detail, but he was looking at the debt prices and saying one can infer what investors regard as the enterprise valuation. But crucially, Dr. Grunwald, in the passage below 192, would not accept this was a valuable cross-check. And if you look, first there's a question, then her answer to that first question, she says the numbers agree. So that's the debt market figure from Mr. Wearising and his 14.7 valuation. And then she says the basis of which we're looking at valuation is on the cash flow generation potential. When we look at enterprise value, we're looking at cash flow generation potential, what the market's looking at, and then you'll see what she goes on to say. So she then goes on to say it's not the same basis on which we're assessing the value. The enterprise value is purely looking at what we were asked to assess, is purely looking at the cash flow generation potential and what an investor would pay for this company looking at the debt. And then over the page, she says, if you look at where the B bonds are priced now, this includes a lot more risks. So just a couple of things on that. First, we say that's plainly correct, that one can't approach this on the footing that the debt market is the same thing as an enterprise valuation. As a matter of principle, they are different.
Nobody was suggesting that.
Well, my lord, with
The
respect,
cross-check on the basis of the market evidence, albeit the market evidence was, as Mr. Smith accepted at least 3 times in that cross-examination, on a completely different basis, and which the judge expressly finds at 193, the fact that market analysts and traders have arrived at a similar EV of Thames for the purpose of pricing the debt on a completely different basis is a valuable cross-check.
yeah, and we say that was wrong. Because if, as seems to be common ground, they are fundamentally different, how could it be a valuable cross-check? It just doesn't actually, with respect, it's not coherent. Because my lord, as I say, the debt market...
The valuation by the judge of other evidence he had as to the value of the company, albeit on a completely different basis. And he expressly takes account of the fact it's on a completely different basis, but reaches a conclusion that provides him with as it were, a comfort blanket, if I can put it that way.
Well, the first point we make is actually, as a matter of principle, something which is a fundamentally different exercise can't be a valuable cross-check, because investors in the debt market are not looking at enterprise value. And that's a point we make at a level of principle, but it was also the point made by Dr. Grunwald. It's also, interestingly, a point picked up by Mr. Justice Mann in the My Travel case at paragraph 57, where he says that these two exercises are completely different. So we submit, first of all here, it can't be a valuable cross-check where something's being done on a completely different basis. But secondly, my lord, on the particular facts here, the trading prices of the debt are plainly unreliable as a cross-check. So Mr. Wearising's evidence was that the A bonds were trading at a discount of 20%. And what he said one could infer from that was the debt market investors therefore assume that they will only get partial recovery. That's why they're trading at a discount. And that's the point that the company continues to make. But the difficulty with that point, my lord, is that Mr. Wearising's own data, which is all set out in his first report at page 81, he said the B bonds were trading at 15%. So a substantial discount, but nonetheless trading at 15%. And the basic point here, which the judge has not grappled with, is that both can't be correct. Because if he wants to look at the price of the A bonds and say, well, look, they're trading at a discount, therefore people are assuming there's a significant impairment, following through that logic, the B bonds shouldn't be trading at 15%. They should be trading, they would have no value at all. On Mr. Wearising's analysis that the company's worth 14.7 billion, the Bs are out of the money to the tune of 3 or 4 million. Billion, I apologise, billion. And so, in a sense, we say as a matter of principle, it's completely wrong to use the debt market as a cross-check, but it's particularly wrong to use this cross-check in circumstances where the data from Mr. Wearising was inconsistent. Because if he's right about the inference he draws from the A bond price, then it can't be right that the B bonds have any value at all. And so we do respectfully submit that the judge was wrong to use this as a cross-check. And as I say, it was obviously an important aspect of his reasoning. It's not the case of simply preferring one expert over the other. The judge has actually started by misunderstanding the purpose of the valuation evidence. That's paragraph 185. And then when you get to the cross-check section, he has regarded something as a valuable cross-check, even though it's on a completely different basis. And Mr. Smith asking the question, saying, well, I know it's on a different basis, but that's why it's a cross-check, that, with respect, is completely incoherent. Because if it's on a different basis, then it's not valuable at all. It's not telling you anything about the enterprise value by looking at the debt prices. So my lords, we do respectfully submit, just to draw the strands together, even having accepted Mr. Wearising's evidence and preferred his evidence over Dr. Grunwald's, the judge did nonetheless make some serious errors in relation to a number of key points. He failed to take account of the ASM, 750 million, failed to take account of the internal inconsistency on the inflation point, 1.7 billion, failed to deal with the true-up mechanism, 636 million, took a shortcut on the multiple, which, as I say, proceeded on the basis of the wrong starting point about significant outperformance. And then when it came to standing back and cross-checking, we say again, it was completely invalid as a cross-check. And in those circumstances, my lords, we do submit the judge was wrong to conclude that the Class B creditors had no genuine economic interest or were completely out of the money. Whether or not one's looking at this on the going concern basis or the relevant alternative, fixing these errors would put the Class Bs into the money. And we do submit that if the test is that we only need to show a real interest, then plainly, given the evidence of Dr. Grunwald and given the errors I've identified, we plainly meet that test. So, my lords, unless I can assist any further, those were my submissions on valuation.
Conveniently brought us to nearly 4:15. Right, we'll adjourn then. Now, Mr. Thornton's up next.
Yes.
Are we sort of vaguely on course? Or?
I think we're a little bit behind, but you'll hear from both myself and Miss Peters tomorrow. We'll have a look at our notes overnight and see if we can chop them back to give you some time back. But I think we are running about an hour behind at the moment.
About an hour?
I think we're about an hour behind. It was anticipated that I would be done today. But I am going to be able to do. I'm not going to be together with Miss Peters more than an hour, and I may be able to be shorter.
And then Mr. Day, obviously, needs a chance, and then we've got two of you. So I only ask just in case we need to sit early or late tomorrow.
My lord, if it assists on the discussions on our side, we budgeted that I would have 2 hours not dealing with releases. So that was the provisional timetable that we'd agreed on our side, allowing for 30 minutes in reply and the quality of time between the sides. So if my learned friend Mr. Thornton's going to be an hour, then that's
How long
going
are you
to
be?
I'll try and trim back a little bit, but it is going to be difficult for me to.
I've
got a very different case to creditors.
Cut you off, as it were, Mr. Day. Could you sit later? Yes. Could you sit till? Can you sit at 10?
Yes.
Can you sit at 10? We'll sit at 10 tomorrow.
I'm very grateful.
We'll give you an extra half hour, and we'll see how we go by sort of this time tomorrow. Thank you. All right, so 10 o'clock.
Court rise.